Hi, and thanks for tuning in to cases that should have gone to the Supreme Court of Canada but didn't. Today we're talking about jury selection. Cases that should have gone to the Supreme Court of Canada but didn't. Jury selection is a very important issue, and it's been the subject of a lot of media attention and discussion lately, primarily as a result of certain verdicts that have upset various people across the country. Mr. Husbands, who was convicted after a jury found him guilty of a serious criminal offense, was also upset by his jury verdict. He appealed, and he appealed on the basis of the process that the judge used for the jury selection. You've probably heard about something called a peremptory challenge, which is a challenge to a juror that allows them to be excused from the jury. A challenge can be made by either the Crown or the defense. In this case, Mr. Husbands challenged a number of jurors on the basis of racial bias, alleging that they would not be able to decide the case fairly because they were biased against him on the basis of his race. Because a number of peremptory challenges were used on the basis of racial bias, the judge imposed a process called a static juror. What happens in a static juror or static trier situation is that members of the prospective jury are assigned to quiz other members of the prospective jury to determine whether or not they are racially biased. It's not done by the lawyers, it's done by prospective jurors. It used to be that there was a rotating system where juror number 1 and juror number 2 would question potential juror number 3. If they were accepted, 1 would sit on the jury, 2 would stay to question, 3 would join in the questioning, and question 4, and they would rotate as such. The criminal code was amended to remove this process and to allow for juror 1 and juror 2 to question the remaining members of the jury. Mr. Husbands challenged that process, arguing that it was unfair to his right to have a fair trial, and he lost. Part of the reason he lost was that he accepted that the judge was going to use that process at the time and asked him to use it, so I don't really know where the challenge comes from. But this case is very important, and unfortunately the Supreme Court of Canada missed their opportunity to set the record straight for the public with respect to peremptory challenges and the makeup of juries. Because this has been such a significant issue in the media lately, and because this has been such an important discussion and topic of debate amongst legal scholars and the community writ large, it was important for the Supreme Court of Canada to get ahead of this, to clarify how jury selection is done and the importance of why it's done in the way set out in the criminal code, and how it's done fairly, and how fair trials happen even where juries might not be what we want them to be. The Supreme Court of Canada missed this opportunity to correct an issue that's of national importance, not in Mr. Husband's case, but outside the facts of his case, and to put some quell on the discussion that's been very emotional and very difficult for a lot of people. It's unfortunate that they didn't see the connection and that they didn't make that decision, but it's also understandable. However, I still think that this is a case that should have gone to the Supreme Court of Canada and unfortunately didn't. You're watching cases that should have gone to the Supreme Court of Canada but didn't. Thanks for tuning in and watching this episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. My name's Kyla Lee, I'm a lawyer at Acumen Law Corporation. I hope you like this video, share it, and subscribe to more videos to share with your friends. And thank you to Brazen Bull Creative for bringing this video production to you.